Please be seated. Good morning. We have one case on the docket today, Terrence Jamar Graham versus the state of Florida. Counsel, if you're ready, you may proceed.
Thank you, Your Honor. Daniel Mafood of Creed and Gowdy on behalf of the appellant Terrence Graham. If I could reserve 5 minutes for rebuttal. May it please the court. The argument today is very simple. It is irrational to punish an offender more harshly solely because the consequences of his crime were less severe. Unquestionably, that's the effect of the 2014 amendments to the juvenile sentencing statutes on offenders like Graham. So no one died during Graham's offense, and because of that, he was convicted of a non-homicide offense, and that brings him within section 775.0823C. That section applies to juveniles convicted of an offense not included in the murder statute, but that is punishable by a term of life imprisonment. So under that subsection, an offender is entitled to review of his sentence after 20 years rather than 15. By contrast, if someone dies during the offense, or if someone had died during Graham's offense, he would have been convicted of felony murder under the murder statute.
That's not categorically true, though, is it? I mean, the statute also requires a measurement of intent, and the Supreme Court has said that a jury must make that finding, correct?
Your Honor, the case law we cited in our brief shows that intent is not an element of felony murder.
It's an element of the sentencing statute, and whether or not the 15, 20, or 25-year review applies.
That's true, Your Honor. So if Graham had been convicted of felony murder, we believe he would have not had the intent to kill, and for that reason he would have review after 15 years.
But we have nothing in the record to support that. Mr. Graham pleaded guilty. There was no trial. There was no jury finding, so we'll never know that. We certainly can't leap to all of those logical conclusions you're asking us to make.
Sorry, Your Honor, you're asking whether we can know that his intent, he would have had intent to kill during his crime?
If the manager had died, if there had been intent, if it had gone to a jury trial, and if the jury had found there was intent. All of those things are necessary before the statute allowing the later or earlier review would apply.
Well, Your Honor, so I think you said it right to start your question, that we don't have any evidence in the record of intent. All we know is that Graham was convicted of a crime that doesn't involve intent to kill. I think if you look at the facts of the case, he didn't strike anyone during his crime. It was another co-defendant who struck the restaurant manager. But even if you don't think of the restaurant manager in particular, even if just someone had died during the getaway and Graham was nowhere near it, whether the police may have shot someone during the crime, the point is there's no requirement that Graham have any different intent.
But isn't the distinction, though, between in your hypothetical where somebody dies, Mr. Graham could have been convicted of both felony murder and armed burglary. It's not a either or. They have different elements, so it's not a double jeopardy problem. He could be convicted of both and sentenced for both then, right, in your hypothetical?
Well, Your Honor, my understanding would be that the predicate felony that Graham was convicted for would enable him to be convicted of felony murder just by virtue of someone dying during the crime. And so you could think of it as a lesser included offense almost. And what is irrational about the statute is that solely by virtue of someone dying, the same felony is committed, the same underlying felony. Nothing's different about his actions or intent. Just the fact that someone died during the crime, regardless of whether Graham intended the person to die and regardless of whether Graham's own actions led to the death, that brings him under the murder statute. And because he didn't have intent to kill someone, he would be eligible for review 5 years earlier. And the argument we're trying to make, very simply, is that the fact that someone dies should not enable an offender to get review earlier. That's a benefit.
But that's not what the statute says. The statute is not simply that someone dies. It also is whether or not the defendant had intent when that person died and what sentence they received. So you concede that if a trial judge within the trial judge's discretion sentenced someone to 19 years, 364 days, they'd have no opportunity for any review. Correct?
Under the murder statute, if they were sentenced to 19 years, they would get review at 15 if they didn't have intent to kill. Graham, for his crime, which is a non-murder offense, would not have review under that circumstance because it's before the 20-year period.
Correct.
But the state in other crimes makes a distinction between manslaughter, which is an F2, 15 years, somebody's dead, but there wasn't an intent to kill, and, for instance, armed robbery, armed burglary, capital sexual battery, all life felonies, where there is an intent. Isn't the intent the distinguishing factor here, and therefore a rational basis for the difference in the sentences?
Well, Your Honor, between the hypothetical I'm proposing and Graham's case, the intent would be the same to commit the felony, and it's the commission of a serious felony that enables you to be guilty of murder if someone dies. So that, I think, distinguishes it from manslaughter, and that manslaughter does not involve a serious felony like armed burglary or robbery. But Graham's intent was to commit armed burglary and robbery. It was not to kill someone. And if someone died during the crime, with that same intent, all of a sudden this statute enables him to get review 5 years earlier. The point of felony murder is that the offense was so serious that even though you didn't intend someone to die, even though your actions didn't kill the person, you engaged in a dangerous felony, and the fact that someone dies means the law is going to punish you more severely for that. To now give you review earlier under those circumstances kind of turns that purpose on its head. And I think it's also important for the court to keep in mind that the Supreme Court has now articulated the maxim that murder is different. Murder is categorically deserving of harsher punishment.
And hasn't the legislature recognized that by providing only one sentence review for murderers versus 2 sentencing reviews for non-homicide offenders?
Well, I think, Your Honor, that does illustrate my point that murder should be treated more severely. But what that doesn't account for...
It is treated more severely. Through the plain language of the statute, it is treated more severely.
That is true, Your Honor, but only for non-homicide offenders who are sentenced to more than 30 years. Graham is never going to receive a second review, so this hypothetical second review that other defendants may be entitled to doesn't make his sentence any better, and that's the point, is that his review period is worse solely by virtue of the fact that nobody died, that he didn't commit murder, which is what the Supreme Court has told us, categorically deserving of harsher punishment.
The modification of statute, if the review is successful and the modification occurs under 921-1402-7, it says if the defender's been rehabilitated and reasonably fit to reenter society, the court shall modify statute and impose a term of probation. You seem to read that to mean he shall be released at that point. Is that correct, that the modification means an immediate release?
Well, in Graham, the Supreme Court said what needs to happen is juvenile offenders need to have an opportunity to obtain early release, and these statutes are the way Florida has attempted to comply with that obligation to provide juvenile offenders with that right. And so I'm interpreting these statutes as enabling offenders to obtain release, to obtain some benefit.
But that release, given that conceivably, I don't think we necessarily have to pass on it to decide the case today, but conceivably somebody could have a sentence modified, say they're serving life, and the court says, okay, I'm going to modify that to 40 years. You've demonstrated maturity, but besides rehabilitation, there's other factors. I think general deterrence and retribution are such that, in a potential crime, somebody needs to do 40 years to be a complete sentence. So the modification doesn't equate to immediate release. So given that there's some discretion there, that the modification could be you get out tomorrow or you get out multiple decades from now, doesn't that provide different classifications such that it's not an equal protection problem?
Well, Your Honor, so I think the point we're trying to make is that there is an opportunity to obtain early release. It may not be immediate. It's an opportunity to improve your sentence. And there's no reason Graham should not be ineligible for that benefit for 5 additional years solely because someone didn't die. It's true that the court, I think I understand your point, that the trial judge may say, well, we're going to pull back on your sentence a little bit, and that might not equate to immediate release after 15 years. The point is, the Supreme Court said Graham is entitled to this opportunity to demonstrate rehabilitation and get his sentence reduced.
And I know on a different factor, the 2 sentence reviews that Judge Rowe mentioned, I know it doesn't benefit your client, but as far as constitutionally beneficial, if somebody was in for, say a 50-year term and got 2 sentence reviews, does that, obviously that gives them more opportunity to demonstrate maturity, right?
That's true, Your Honor, and that's sort of complicated. I think it's a tough thing to determine whether you'd rather have a later review but 2 shots versus the earlier shot. If you demonstrate maturity and rehabilitation after 15 years and get out, then for you, you'd rather get that shot. But I think the situation is much clearer here. We're fortunate that this really tees it up perfectly. We have a situation where there's no second review for Graham. He is going to have to wait 5 more years, and the only reason for that is that nobody died during his offense. And I think, as we've argued, that turns the whole tenor of the statute, the punishment for murder being more severe, it turns that on its head, and it defies the Supreme Court's maxim that murder is categorically worthy of more severe punishment. So with that, I'll save the rest of my time for rebuttal.
Thank you, counsel.
Thank you.
Good morning. May it please the court. Caitlin Weiss for the Office of the Attorney General on behalf of the state of Florida. Your Honors, the burden in an equal protection case is extremely high. The defendant has to negate every conceivable basis that must support the legislation. And in this case, because we're under rational basis review, the state has to show that this statute has a rational relationship to a legitimate state purpose, which I think is quite clear from the structure of the statute in this case. The legislature wanted to proportionally penalize offenders, juvenile offenders, for their actions based on their intent and the level of criminality of their actions. And I think that if you step back and look at it as a tiered system, it makes a great deal of sense. At the top level of the tier, you have a 25-year sentence review for those offenders who killed, attempted to kill, or intended to kill. They had the most intent on the most serious crimes. They're the most culpable. At the next level, you have a 20-year review for those who intended to commit life felonies, the most heinous non-homicide crimes, as Judge Bilbrey mentioned, the sex bats, the armed robberies, the armed burglaries. They intended to commit these crimes. They're highly culpable. But the legislature recognizes that there is a distinction between a non-homicide and a homicide and gives them a second chance at review at 30 years. Then, at the bottom, you have a 15-year review where you were involved in a homicide but had no intent to kill. You did not kill, you did not attempt to kill. This is, by its very description, a very narrow class of offenders. This is the getaway driver. This is the juvenile who went to, rob a store but didn't know that his co-defendant had a knife. He went to a fight but didn't know that somebody had a gun. This is a very narrow class of offender where their intent is in serious question, and the legislature has determined that that lack of intent warrants an earlier review period.
Well, counsel, Graham argues that, had the manager in this case died, he would have been entitled automatically to that 15-year sentence review.
I very strongly disagree with that. First of all, and I think that this point was well made when counsel was speaking, he would still have committed an armed burglary. And I believe that there's plenty of case law out there that in a felony murder situation, you can still be charged with the underlying offense. So we're playing a game here with this hypothetical with a lot of assumptions. So, I think that if we want to assume Graham could still very easily have been charged with armed burglary, armed robbery, and felony murder, still be convicted of both, and therefore he would still get the 20-year sentence review. And I think that a conflict between a 20 and a 15-year review is outside the scope of today's conversation. All this to say, this hypo is not valid. If the defense's hypo is that all things the same, the only thing different that the manager dies, Graham gets 15, no, that's not the case, because he still committed one of these very heinous life felonies that the legislature has determined warrants a 20-year review period. Now, I think that if we bend the hypo, and I think that one of the cases defense counsel cited in his reply brief was Dean, In that case, the underlying felony was just a burglary, so not a life felony. In that case, Dean then would not have committed a life felony, would be in that very narrow class of offender, that 15-year class who, had no intent to kill, no intent to participate. So I think that the big difference here, and the reason that this hypothetical fails, is that Graham still committed a crime that the legislature has determined warrants a 20-year review. And I think there's a difference between offenders who commit those type of crimes, who will still always get the 20-year review, and the offenders whose felony murder charge is predicated on a non-life offense, who then fit into that class designated by the legislature that they have deemed deserving of the single shot at a 15-year review. So I disagree with that hypo, and I think that if you look at it as a tiered system, as it relates to the purpose of penalizing juveniles based on their intent and culpability, it makes a great deal of sense. And the fact that, defense counsel disagrees with this structure, believes that it should be, that the 20 years should be 15, essentially that the second and third tier should be flipped, that's not grounds to find a statute unconstitutional. Disagreeing with the statute and disagreeing with the structure is not a basis for that. I'm sure that everybody in this courtroom can think of a statute that we disagree with. That does not make them illegal. All that has to be shown is that this statute relates back, has a rational relationship to a legitimate state purpose, and it very clearly does. I also think it's incredibly important to note that there are still multiple reviews for non-homicide offenders. They still receive that second bite at the apple. Defense counsel's only argument against that point in the briefs, in the reply brief, was that, well, only if there's a rational basis does that make sense. The case law is very clear that not every single person in a class has to get every single benefit. It doesn't have to be mathematically nice, as long as there's a rational basis for it. In this case, there's very clearly a rational basis for it. It applies equally to all members of Graham's class, which is these non-homicide juvenile life offenders. That second review really distinguishes this case, or non-homicide cases, from homicide cases. And it really reinforces the intent element of this crime and reinforces the fact that the legislature set this up recognizing both the difference in intent and culpability and the difference between homicide and non-homicide crimes. So again, you may not agree or like this structure, but it does make sense and it is related to a rational state purpose. So if there are no further questions, under equal protection, a statute can be upheld if there's any conceivable way that it relates to a rational state purpose. There is an obvious such rationale in this case. And so for that, the state would ask that this court affirm the denial of appellant's post-conviction relief for the arguments here and those in the brief.
Thank you, Your Honors. May it please the court. One of the examples my colleague gave during her response was an offender who participates in a robbery but doesn't know the other person has a weapon. And that's ironically exactly what happened to Graham. He didn't wield a weapon. His accomplice became armed during his crime, and that's what he was convicted of. So in this scenario, if someone died, he would be exactly the felony murder situation that my colleague is saying, we don't think they should have to wait so long for a review. We should give them a review after 15 years. But that's not the way the statute works. If someone dies during your crime and you've committed an underlying felony, you're guilty of felony murder. You're a murderer now. And that's what the Supreme Court has instructed us is deserving of more severe punishment.
Is there an argument that the early review could be more of a penalty towards homicide offenders. I mean, if you've got to demonstrate maturity after, say, 1 year, obviously that's not what the statute says, but here you've got 15 years for the homicide offenders that didn't intend to kill to demonstrate maturity, and that's their one shot to do it, whereas someone in the category of Mr. Graham would have 20 years, a little more time to demonstrate maturity. I mean, obviously, clearly he would like his review quicker, but conceivably, giving somebody 5 more years to demonstrate maturity to get them out of potentially a life sentence might inure to a defendant's benefit.
Respectfully, Your Honor, I think I understand your point. You have 5 more years to take your one shot. You can prepare more. But respectfully, I don't think that's the way the statute works. I don't think the legislature was trying to confer a benefit by giving you 10 extra years to prepare for those who intended to kill. If that were the approach, if prolonging the review were supposed to be better, for one, it turns all of the arguments we just heard on their head, because we're told that there's some way where the lack of intent makes you entitled to this early review even though someone died. And moreover, just looking at the people convicted of murder, those who didn't intend to kill have this earlier review. I think it's clear that the statute intended that to be the most favorable treatment, and that once you intend to kill, you have to wait 10 more years. I can see that maybe it might work out to someone's benefit in a particular case to have 10 more years. I don't know that if you're in prison and you feel you're not ready, you can't seek your review, you can't wait to petition for review after those first 15 years have elapsed. So I think for that reason, it wouldn't really work to your detriment. But I think just realistically, anyone who's in prison, they know that they want to get out as soon as possible. So I think that's how you have to interpret the review period. I don't think it works to say, well, actually, it's better to be in prison longer and before you take your review. On the subject of the 20-year review if you commit the felony, so the way the statute's worded, if you're convicted of murder and you didn't intend to kill, you get review after 15 years. If you're also convicted of a life felony, another life felony that's not your felony murder conviction, you get review after 20 years. So I'm not exactly sure I understand what the point of the hypothetical was, but the idea that you would be entitled to a 15-year review and the 20-year review, well, obviously you'd have your 15-year review before the 20 years have elapsed. So that just shows that if someone dies, you're getting a better review period. You're getting the shot 15 years earlier. And I think I just don't understand what the rational basis would be for that. I understand that it's a very lenient standard. I understand that the fact that I don't like a statute doesn't make it unconstitutional, but what does make a statute unconstitutional is when there's a distinction that is not rationally related to a legitimate purpose. And that's what we have here. We have a statute that is taking people who are guilty of what the Supreme Court has told us is categorically the worst type of offense, and we're giving them more favorable treatment under the statute than you would get for a less severe offense, for an offense that's merely a predicate for the felony murder. So, and I've heard this argument, I've read this argument in brief, and I heard it again today, that there's some way in which someone who intended to commit a felony might be worse than someone who didn't intend to kill. But I think what that misses is that in both cases, the offender intended to commit a felony. The only difference is that someone died. And there's just no rational reason to treat the person whose offense resulted in a death more favorably under the statute. Thank you, Your Honor.
Thank you, counsel. Thank you both. This court will stand adjourned.
All rise.